What if you landed at a U.S. airport with your green card in hand and still got stopped, questioned, and told you could lose your permanent resident status right there at the gate? That is exactly what is happening to thousands of green card holders in 2026. U.S. Customs and Border Protection, CBP, has rolled out three major enforcement changes that every lawful permanent resident needs to know about before they travel internationally. Whether you've had your green card for 1 year or 10 years, these new rules affect you. Stay with us until the end of this video. It could protect your status. Welcome to Global Immigration Scope, your trusted source for accurate, up-to-date immigration news from around the world. I'm Host Name, and today we are breaking down three new CBP enforcement rules that are directly impacting green card holders at U.S. airports in 2026. Everything we cover today is based on official sources, including the Department of Homeland Security, U.S. Customs and Border Protection, and the USCIS. We'll also reference Presidential Proclamation 10998 and the DHS Final Rule on Biometric Data Collection, which both took effect at the start of this year. This is not a scare story. This is important information you need in order to protect your legal status. Let's get into it. So, what exactly changed, and why does it matter? Starting in late 2025 and into January 2026, the U.S. government expanded CBP's authority at all ports of entry: airports, land borders, and seaports. Three major enforcement changes are now in full effect. What happened? CBP has intensified its inspection process for green card holders returning from international travel. Officers are now conducting more secondary inspections, collecting expanded biometric data, and in some cases, asking green card holders to voluntarily give up their status using a form called the I-407. Why did this happen? The Trump administration has prioritized stricter border enforcement and national security. A series of executive orders, a new DHS biometric data rule, and Presidential Proclamation 10998 all expanded CBP's tools and authority to scrutinize re-entry at U.S. borders. When did it take effect? The biometric data rule took effect December 26, 2025. Presidential Proclamation 10998 went into effect January 1, 2026. Enforcement trends have been intensifying throughout early 2026. Who is affected? All lawful permanent residents. Green card holders, especially those who travel internationally, have been abroad for more than 6 months, have any prior legal issues, or are nationals of countries under heightened scrutiny. Now let's break down the three key rules you need to understand. Rule 1. Mandatory biometric data collection at all ports of entry. Effective December 26, 2025, a new DHS final rule requires CBP to collect facial biometric data, photos and fingerprints, from all non-U.S. citizens at every entry and exit point: airports, land borders, and seaports. This is not just for new visitors. It applies to green card holders every time they return to the U.S. What's new is that this now includes children under 14 and adults over 79, groups that were previously exempt. CBP also links your live photo to your travel document photo and existing database records. If there is any mismatch, inconsistency, or flagged record, you may be held for secondary inspection. The practical impact: your identity, immigration history, criminal database records, and even travel patterns are being checked instantly using facial recognition technology. One old arrest, one minor discrepancy, and you could be pulled aside for hours. Rule 2. Heightened secondary inspections and device searches. Under Proclamation 10998, Presidential Proclamation 10998, effective January 1, 2026, expanded travel restrictions for certain nationalities. Green card holders are technically exempt from the outright ban, but that does not mean your re-entry is automatic. CBP officers are now conducting far more secondary inspections on returning permanent residents. In secondary inspection, officers can question you in detail about your life in the U.S., your travel history, your employment, and your ties to this country. They can also search your phone, laptop, and other electronic devices, and they can hold those devices for days. If you are sent to secondary inspection, everything you say can be used in immigration proceedings. You are not required to answer every question beyond confirming your identity and presenting your documents. Remain calm. Be polite but firm, and if at all possible, contact an immigration attorney. Rule 3. Pressure to sign form I-407, the abandonment of status. Trap. This is the rule that is causing the most alarm in the immigrant community, and the most important one to understand. There are now confirmed reports that CBP officers are detaining green card holders at airports and encouraging them, sometimes pressuring them, to sign Form I-407. That form is titled The Record of Abandonment of Lawful Permanent Resident Status. In plain language, if you sign it, you are giving up your green card voluntarily. Here is the critical fact. Signing Form I-407 is entirely voluntary. CBP cannot force you to sign it. You have the right to refuse. If an officer asks you to sign this form, you can politely decline, request to speak with a supervisor, and ask to be issued a notice to appear, which means your case goes before an immigration judge, where you have legal rights and can fight your case. Never sign Form I-407 under pressure, especially if you do not fully understand what you are agreeing to. Seek legal advice immediately. Important reminder, if CBP takes your phone or laptop, always request a receipt. This creates an official record of the seizure and gives you documentation to follow up later. So what does all of this mean for you as a green card holder? First, the risk picture. If you have been outside the United States for more than 6 months, CBP may question your intent to maintain permanent residence. Beyond 1 year abroad without a re-entry permit, called Form I-131, your green card can be considered invalid. Officers can refer you to immigration court to begin removal proceedings. ICE detention has reached record levels in 2026. Reports show that the vast majority, nearly 92%, of recent detention growth involves people without criminal convictions. This means that even minor document inconsistencies or older legal issues can result in prolonged airport holds. Second, there are ways to protect yourself. Keep your trips under 6 months whenever possible. If you expect a longer absence, apply for a re-entry permit before you leave. Carry strong evidence of your ties to the U.S. Pay stubs, lease agreements, bank statements, tax returns. Keep a digital record of all your travel history. Third, and we want to be accurate here, the majority of green card holders are still admitted when they return. Most returning residents are not detained. But the friction is real, and being unprepared significantly increases your risk. Looking ahead, what should green card holders expect from U.S. immigration enforcement? From a policy analyst perspective, the current trajectory points to continued, and likely expanded, enforcement at ports of entry. CBP has stated it plans to roll out the full biometric entry-exit system at all major airports and seaports within the next 3 to 5 years. This means facial recognition, fingerprint matching, and database cross-checks will become even more comprehensive and automated. We may also see further executive actions targeting specific nationalities, expanded social media disclosure requirements, and deeper cooperation between CBP, ICE, the IRS, and the Social Security Administration to identify potential status violations. For green card holders planning to apply for naturalization, keep in mind that extended absences can also reset the clock on your continuous residence requirement, even if a re-entry permit protects your green card status itself. The bottom line? The window for traveling internationally without careful planning is narrowing. Staying informed, staying documented, and staying connected to a qualified immigration attorney is more important now than at any point in recent memory. Let's quickly recap what we covered today. Rule 1. CBP now collects mandatory facial biometric data from all non-citizens, including green card holders, at every U.S. port of entry, effective December 26, 2025. Rule 2. Under Presidential Proclamation 9998, CBP officers are conducting far more secondary inspections on returning permanent residents, including device searches and detailed questioning about your U.S. ties. Rule 3. CBP has been reportedly asking green card holders to sign Form I-407, which voluntarily surrenders their status. You are never required to sign this form. Politely refuse and seek legal counsel immediately if this happens to you. If you found this video helpful, please give it a like and share it with someone who holds a green card or is planning to travel internationally. Your questions and comments are welcome below. Our team reads them all. Thank you for watching Global Immigration Scope. Stay informed and subscribe for the latest immigration news and visa updates from around the world.